Get us started.
Sure. So my name is Colleen Koch. I, along with Doug Stevens, am one of the co-chairs of the civil litigation section of the Boulder County Bar Association. So good evening, everybody, and thank you for joining us for tonight's CLE presentation, Claiming the Visual High Ground, presented by Stephen Padwe of Elite Trial Consultants. Very few people spend more time in the courtroom than trial consultants like Stephen. This volume of trial experience allows him to provide information on judges and courtrooms, as well as insights into jury behavior, witness credibility, and strength of evidence as it comes in. Stephen has worked with many of Colorado's most active trial teams, which gives him perspective on how similar cases have been presented and also the tactics you're going to see coming from the other side. Stephen has been operating as a trial consultant for more than 3 years. In that time, he has assisted in approximately 200 different cases. Stephen specializes in helping teams shift gears from motions and filings to emotions and persuasion, accomplished through the eloquent application of design and technology. And I have to say, I personally had the pleasure of working with Stephen on a jury trial in June, and I can attest that his expertise and his insight were invaluable. So with that, I'm going to hand the reins over to Stephen. Stephen, thanks for being here.
Thanks, Colleen. Very much appreciate the introduction. This particular presentation, as Colleen said, is called Claiming the Visual High Ground, and it's near and dear to my heart. It's something that I created, and there have been a couple of different iterations of it, but this particular presentation was created kind of right around the beginnings of COVID and has evolved with the changing environment that we've had. So one of the fun things, like she mentioned, is that we're in trial a lot, and as trends begin to unfold, we're one of the first groups of people to see them. Be able to give you real-time feedback on a variety of different things, how people are coping with the environment that they're in, and lots of different stuff like that. So I really want to thank you for being here. Appreciate you taking some time tonight to listen to what I have to say and hopefully learn some stuff about how cases are being tried these days and how people are incorporating different visual elements to enhance the persuasive capabilities that they have in the courtroom. So let's see if we can, we need to share my screen. That would help, right? So we'll start with that, and Colleen, if you just want to let me know when you're seeing the screen. All right. So again, this presentation is called Claiming the Visual High Ground, and we don't want you just to put out a mediocre effort. It's called Claiming the Visual High Ground because you make a conscious decision to do that, or you make a conscious decision to relinquish it to the person or the team that you're going up against. Simon Sinek is an author of one of my favorite books, and it's titled Start with Why. And in this book, he examines the reasons why various different companies and people make an impact on their environment, why they're successful in a way that others aren't. And when he distills it all down, it comes down to why someone does what they do, or why a company does what they do. So I want to ask you for a second here, why is it that you do what you do? And specifically, as it relates to trial, why is it that you're doing what you're doing in trial? And if you answer that, or to answer that question, a lot of people will say something to the effect of, I want a good outcome for my clients, or I care about the people that I help, or have an obligation to do my best, an ethical duty. And these are the types of sterile responses, that a lot of people will, people in your position will provide. But when we dig down deeper and we get real, we know that there's more than money on the line. What you do matters. It changes people's lives in profound ways, and your performance in trial, quite frankly, has an amazing impact on businesses and lives. So I was involved in a case probably about this time last year, where a family, we'll call it a farm, uh, it was basically a ranch, had been in the family for 3 generations, and they were getting sued for somewhere in the neighborhood of $40 million. And literally, if we didn't prevail in trial, they would lose the farm. It was bet, it was hanging in the balance. And our team's ability to persuade the jury made the difference in, a huge difference in the legacy of this particular family. Now, we do all kinds of different cases out there. It could be a business that ceases to do business anymore. It could be, all kinds of different things are in play. But you get the picture. There's a lot more going on than just a, paper being passed around and a good outcome being achieved. So just remember, what you do matters, and there's very real outcomes associated with your ability to persuade in trial. And at the end of the day, we all enjoy winning, right? And at Elite Trial Consultants, we want to win with you. That's part of, I want to invest in every case that I'm a part of and give it the attention that it needs. It's not a transaction for me personally. And this isn't a complete pitch about what it is that what I do, but when you're looking for people to to ride into trial with, make sure it's somebody who cares about the outcome of the case that you're working with as well. It's a trait that is probably not too difficult to look for, but it's important because we want to win together and we want to win big. So before we dig too far into the weeds about how to go about doing this, I want to ask you another why question. And the question is, why is it worth spending time and money and effort to create a visually persuasive component of your opening statement, your expert reports, their testimony? Why is it important? And why is it worth putting this effort into developing these things? And the simple answer might be that today's jurors may have a shorter attention span than they used to. Right? There's some theories out there that maybe they're more easily distracted because of all different kinds of competing influences that people experience, while they're in court, and the things that are exerted on them elsewhere, right? But at the end of the day, I don't think that holds water. I think that physiologically we're very similar to the way we used to be, and there's not, you still have the same challenges that you used to have in court. And if something like Netflix tells us, or service like Netflix tells us, that it's not that people are incapable of paying attention. They just need to be accessed and entertained, if you will, a little bit differently. So statistically, the survey was put out there that 92% of people who have watched Netflix have attested to the fact that they have binge watched, or they've watched more than 3 episodes in a row. So again, there's so many different examples out there. If you put yourself in the position of a juror, it's not that you can't pay attention. It's just that you want to pay attention to the variety of different things. And there are other things that get your attention and hold it better in this environment. Because we're in an age where we are consumers of digital content. So it's not that we can't pay attention. We just need things served up differently. And so evidence presented in a visually appealing way in a digital wrapper is something that we are very accustomed to at this point. And it used to be, you hear the phrase, you can't trust, what's on the internet, and so on and so forth like that. That's, granted, there's still plenty of things out there. You need to do your due diligence, but people are very accustomed to taking in what they see through their eyes, delivered in some sort of visual digital media. That this is a great way to keep people's attention and to benefit from the same principles that allow Netflix and these streaming services to become companies like they are. So if you hook them the way that the other services do, you can again enjoy that same benefit of a captive audience, people who are going to be engaged in the case that you're putting on if you don't bore them to death. And and talk them into oblivion. So as humans, we're visual people, and looking at how much information ends up in our brain should tell us something about effective communication. So roughly 7% of what is in your brain, and again, this is, there's some illustrative license here. Scientifically, there's different ways to quantify, the brain itself and its contents. But if we're looking at memory banks, for example, that's where this is derived from. So roughly 7% of the information, or 7% of the data, is being occupied, or space is being occupied or got there by input from touching, tasting, and smelling. And roughly 11% has arrived there via things that we have heard. And a whopping 82% of what is in our brain arrived there via seeing. So we're highly visual people. And not to throw rocks at your profession, because obviously without all of you high quality people here, I don't have a job to do. But you forget that reading documents is not what we're going to call the native language of today's triers of fact. People are more visual by percentage, and so odds are your jury is not going to receive information the same way that you do. You guys are tremendously talented at taking documents and words and assembling them into a picture. And that's just not a skill that most people have. Most people want to see a picture and then associate the documents and such to support it. So the bottom line is, if you have 15 minutes to persuade a jury and to fill them with information about your case, the maximum amount of information that you can provide somebody via their ears and everything else, you have a relatively small amount of bandwidth. But if you've got 15 minutes, it makes sense to use something that has 7 times more capability to convey information, than simply utilizing the ears. So lots of people have different styles, and will switch back and forth from engaging via the eyes and trying to connect emotionally. But at the end of the day, when it comes down to raw amount of information that someone can receive and retain, the eyes must be utilized, right? And we're not in the business of, selectively removing, advantages that we have. We're in the business of capitalizing on the advantages that we have. So utilizing the eyes simply from their ability to get information in the brain makes a lot of sense. The second, and I'm not going to call it scientific, but we'll call it we can call it, the science behind why you want to utilize the eyes and go through with creating quality visuals, is that the eyes are the authoritative sense. Or when we ask ourselves, what is the authoritative sense? And I don't believe, I'm going to pause for just a second here, and I'm going to reshare this, because I don't think I checked the little box that's going to allow you to hear what I want to play. So apologize for that interruption, but we're going to do it just to make sure that you are going to hear the sound. So I'm going to play just a quick clip here. So you probably heard that, but at the end of the day, you don't necessarily trust your ears. So your ears are going to cause you to perk up. You're going to listen. You may start to react. If you were in the woods, right, you'd probably stop and you'd probably listen closer. But if you saw this, right, if you were fly fishing, or if you were, hanging out on the, on the riverside, on a little river beach with your family, and you saw this, you probably wouldn't be thinking twice. You might freeze for a second, but you would be making very real calculations about what your next move is going to be. You wouldn't be waiting for more information. So at the end of the day, if you can't hear the bear that's here, are you any less convinced that it would be there in front of you if you actually saw it? And I would contest that the answer is no. Seeing is our authoritative sense. Hearing things, just naturally, we don't trust the information the same way. So when given a choice, it's pretty clear that seeing is the de facto sense here, and that's where the phrase comes from, that seeing is believing. But we don't just have to see things, right? If we can see and hear them, create a very rich memory, create an event that is wired in our brain a little bit differently than simply seeing or hearing. So when it comes to retention, you want people to both see and hear something. And by that, you can be talking about a document, you can be seeing something, you can be seeing data arranged in various different ways. But engaging the senses is one of the keys to retention. And the more senses that you can, attach to, and if, something we'll talk about a little bit later, but adding emotion, layering that in also is how you create, pieces in people's minds that are difficult to dislodge. So the percentages are all over the place, and I'm not going to reference the studies here. There was lots of them, but no one disputes that seeing along with having an auditory message creates far better retention than simply listening to something by itself. So we've talked about a variety of different things, but one of the things that the eyes also do is they refocus attention. So I'm not a fan of having a visual just as a gimmick, but you can't not focus. There's certain movements, right? We have this joke about the squirrel, right? We've got our golden retriever Doug. I don't know if you guys have seen the movie Up, but it's a fun little movie, and if you have, you know what I'm talking about, right? Every time the squirrel runs by, the dog jolts his head, stops what it's doing, and is distracted in that moment. It must, take stock of what the squirrel's doing. And we're not too dissimilar. Yes, we've tempered our reflexes, and we are perhaps less distracted by movement. But in the courtroom, it's a very effective way that if you have jurors that are nodding off, and I promise you, I've been in trial near constantly, for the last several months for sure, most of this year, and there's always a juror or two that can't seem to stay awake in the courtroom. And this is one way to induce everyone's to pay attention again, right? People have to reshift in their chair to look at something. It's just the way it is, right? So if you have a tool at your disposal, again, do we not want to use it, just because it might be just the teeniest bit cheesy? And I would contend that it's how we're wired. So when you have a piece of information that a jury must absolutely understand, a component of your case that's important, draw focus to it simply with some movement, drawing someone's attention to a place in the screen, and ideally having a quality visual to go along with it is a great way to force someone to re-engage in what you're talking about. So we've gone through a handful of things so far, talked about why you do matters, right? We want to enjoy winning because losing is no fun. None of us want to do that. We're all highly competitive people here, I'm sure. Our jurors haven't necessarily changed fundamentally, but we access them via digital means because we're now consumers of digital content in a way that we didn't used to be. The eyes are a very efficient conduit of information, or a very they're a high bandwidth transmission capability, and so we want to use that to convey the most amount of information. And not only that, we want to do it because we trust our eyes over the other senses. What we see is something that is easier for us to accept and internalize than perhaps speaking alone. And seeing and hearing, and again, tapping the eyes and doing that provides for retention. They also control our attention, and we can use visuals to refocus. We can take advantage of what the eyes are able to do there. So we've gone through all those things. Now we talk about the how, right? Hopefully at this point you understand that there's real reasons why we want to do it. Now, how do you go about getting yourself to a point in trial where you not only have these, where you have these tools that you're able to use and then use them. So, you're probably looking at this slide saying, Stephen, what are you talking about? What is this slide, right? Why are we looking at a children's book? And at the end of the day, a lot of what I do is related to telling a story. And if you think about how we've grown up listening to stories and consuming them, they start with simple concepts that are illustrated, right? We have words, we have pictures, and in a great story, all kinds of things are being conveyed. In this little book here, we see our poor old fox has lost his socks. You can see on the expression of the fox's face, he's dismayed by this, right? There's emotion that's being conveyed. And we need to do that, even though a lot of what occurs in the courtroom is, sterile and black and white related to the law. That's not where it ends. We need to engage the audience emotionally, intellectually, and visually, right? And doing it in a way that is seamless, that feels natural and pure. It's about telling a great story by utilizing text, imagery, feelings, and all of that woven together to speak into unison to someone. So when we're telling a story, a lot of times you're going to have something, I like to call it the 60-second shell. For big cases, it might be longer than that. But think of it as like an elevator speech. If you're going to try to tell somebody something, and the time it takes for the elevator to get from wherever you're at to the floor that you're going to, or from the floor to the basement, you have a limited window to frame out what is going to occur. So I like to call it the 60-second shell. But at the end of the day, we have a quick opportunity to paint a picture and capture at a high level the important elements, of a case, and foreshadow some of the more complicated topics perhaps, and create some curiosity and some incentive for your audience to listen further. So in there, if we can capture the emotion, we can capture some of the important pieces and some of the complexity, but we have to do it quickly. You can't get into the weeds too quickly or you lose people, right? But if you do it effectively, there's a hook and there's an incentive to continue paying attention. I like to think about this in the context of the picture on a puzzle, right? If you don't know what kind of puzzle you're trying to assemble, it's very difficult for people to actually do it. Grab some water just real quick. If you have a puzzle and you just have pieces and know where to put them and no idea of what you're building, your odds of success are much less. Your odds of wanting to abandon the puzzle are very high. But all pictures, puzzles rather, come with a picture. And that's to give you an idea of what you're going to be doing for the next week, let's call it, right? Very similar to trial. You need to paint a very good picture so that people know what to do with all the pieces when they receive them. I like to think of it as providing a receptacle for evidence. So this is referred to in the literature, as creating a framework, helping people identify where bits of information belong. And if you think about, having an uncomfortable conversation with somebody, let's just say you're talking about a topic and you can't tell whether they're for or against a particular topic you're talking about, you're not going to know how to react to what they're saying. And what happens is that you just sort of hold it in limbo, and you just hang on to a bunch of information, but it doesn't sink in, and you can't have a natural conversation. But if you've done a good job painting the picture with telling your story immediately, you provide a nice place for evidence to go in people's minds. They know what part of the case it's related to. They know why they're hearing those pieces of evidence. And that's something that we want to accomplish very quickly. And then, further in the opening, again, we're painting a big picture, before the really big picture, before the details. So it's important to do, and that's something that, we want to assist with. The next component I want to talk about is temporal and spatial orientation. So when it comes to the passage of time, in almost every case, there's some element of proximity of events to one another. Things happen really fast, or they happen really slow, or there was years in between the time that someone should have known there was a problem and then did nothing to fix it, or the sequence of events happened so fast that nobody could have dealt with them. But modeling that passage of time is something that's very important. That's done very frequently, and that's something that a visual is an excellent tool for. Spatial orientation. Where did something happen? There's lots of different reasons why you would want to go about orienting the jury to time and space. And again, the best way to do that is incorporating visual elements. When it comes to the stories, I like to joke with people and say, hey, show, don't tell, right? There's show and tell, but the telling part comes naturally to just about everybody. So the showing piece, though, is less comfortable. Right? Sometimes, there's lots of stories out there about things that people couldn't use, or there was an objection to, or something along those lines. But I can tell you, in practically speaking, things that are done well based on the evidence created to assist the jury. There's just not a lot of issues when it comes to getting things in and developing them well. But the simple fact is that by showing people things, you can tell the story very quickly. So our poor Fox here, let's say when he lost his socks, he filed a police report on X date. And on May 21st, right? So we see our police report, and the fox continues his search, and he looks in the chest. Later, he looks in the cabinet, the dresser, the clock, and eventually our fox finds his socks in the box. We can overlay lots of different things to emphasize, again, the time that occurred or the lack of time that occurred. And utilizing these tools helps tell the story much faster than can be done with simply words alone. We talk about where the fox search. Well, we can look in the bedroom, right? The living room, the clock, and eventually he found them in the box. Again, these are elementary examples of what can be done. There's lots of different tools that are used, right? The last couple of cases that I've done have actually been personal injury, and then I have last week I did a contract case, breach of contract case on a large oil and gas pipeline that was being built. A couple weeks from now, I'll be doing a construction defect case, and each of these, when done well, are going to have their own variation of visual that helps tell the story. So they're portable all over the place. Don't think to yourself, okay, that's just not applicable to what I do. Even family litigation, complicated estate. There's elements of that lend themselves to being developed visually. So that's the idea behind it is you're telling a story, and the better you tell your story, the better the jury's going to receive it. And then the better they're going to be able to receive the rest of the evidence that comes subsequently. You have a place for it to go. They're going to understand the emotion behind it, and they're going to understand why you're telling them what you're telling them. The evidence isn't just going to be impacting on the surface of dead, tired eyes and people. So at the end of the day, the way we go about doing this is by collaborating early, right? It's an iterative process. Some stuff comes together really quickly, but whoever you decide to work with to develop visuals, I would encourage you to get them involved earlier on in the case than perhaps you're accustomed to. Get them key documents, right? I always want to read through, depending on which side we're on. If it's the plaintiff that we're working with, the complaint is usually pretty helpful. A mediation statement is pretty helpful. These are documents that I want to read to get up to speed on the case, so that so that I have a basis for for forming some opinions about how the evidence could be presented. So I can tell you, hey, I've done 4 other cases like this, and this is how they did it. This was effective. That wasn't as effective. This is something that you might want, might not, but get us the relevant facts. I love to read about the cases, and there's a lot of companies out there. Actually, I can't say that. Historically, this is something that I don't charge for unless it's something that you actually want to use, right? So you can get people involved, and they don't have to run up a huge bill to give you some ideas. Yeah, if you like the ideas, then we'll develop them, and there's a cost to it, but that it'll tell you something about who you're working with if they're going to get up to speed on the case and help you develop some ideas. We want to see expert reports, right? We want to see what kind of what is your expert going to bring to trial with them. So a lot of the guys out there are going to create elementary visuals to go along with it. Some of your experts are going to create great stuff on their own, but for those that don't, you can have a fantastic expert that can't get through to anybody on the jury, without having some assistance, and that's something that we do very well. So once you just send us stuff like that, any key documents in the case, if there's any visuals that have already been produced, they can be enhanced. Blueprints are something we deal with all the time, where they're just a cluttered mess, and we take away the things that don't need to be there, highlight the things that do. In your civil litigation cases, or stuff that might be more along the lines of a contract case, diagramming the contract structure, terms, things like that can be very helpful. And that's something that you want to get in the hands of whoever you're working with as quickly as possible. I mean, there's lots of utility to it. I don't think that there's a single person that, it's probably a bold statement, but I don't think you could find one that's worked with somebody on developing visuals and didn't come away with some piece, some nugget of case strategy that they might change or adapt, or at least feel like they've gotten more clarity about the case by thinking through how they're going to tell the story. So it's a great exercise to put yourself through, regardless of how comfortable you are with developing things later. Just thinking through the process of how you're going to tell the story is an excellent exercise in preparing for trial. So earlier the better is my suggestion. And I say that by not 2 weeks before trial, ideally a couple months out, around the time of mediation, leading up to mediation. Your arbiters, mediators, judges alike, they don't have time to read through an endless stack of documents and find the needles in the haystack, right? They all inherently are a bit lazy and want things spoon-fed to them. And not only that, when you're heading into mediation, if you're demonstrating that you're already prepared with a couple of key, a couple of high-quality demonstratives that help them understand your position, you're also conveying the strength of your position to them by letting them know that you are preparing for trial. You are preparing to put your case on. And it's not lost on people that deal with these things all day, that you have, taken some extra time to help make their life easier and convey the position of your client in a very solid manner. So where do we use demonstratives? They're going, or visual aids, whatever you want to call them. In opening, they're very, very common. We develop a lot of stuff for use with expert witnesses. If you have a key witness, corporate representative or somebody who's testifying, this is a great way to keep them on task. If they have some key things that they're going to be trying to explain, not everybody, is used to and is comfortable with the courtroom. It's a good way to help people stay, stick to, the script, if you will. in terms of the testimony that you want to get across. And then naturally in closing, you're going to find a lot of demonstratives used in closing to summarize evidence and to to argue the case as effectively as possible. So there's lots of different kinds. There's org charts in your, helping people understand the key players within a company. You might have entity charts helping people understand the various different structures of, in this example, contractors and suppliers and such. Timelines are very common to help explain a variety of different things, a sequence of events. It could be medical treatments, lots of different ways to display the information. And that's something that someone, talented designer is able to help you determine what's going to be best for your particular case. You've got lots of different graphs, charts, diagrams, maps, and at the end of the day, sometimes an animation might be the best way to, to convey some information. So this was one from a recent case where there was an air conditioning unit that was, involved, and there was some, trying to explain to the jury how an air conditioner works is a very difficult thing just to talk. And again, you might be able to talk to someone for 2 hours and have them not understand the volume of information that you can convey in just a couple of minutes with a picture and then adding some movement to it. So we will help you determine what's right for the case. But at the end of the day, sometimes, a picture's worth 1,000 words and a video is worth 1,000 pictures. That makes sense. So lastly, where do you use them? I say, if you have an emotion that you want people to feel, think about a graphic there to go along with it. If you have something that's very important that you need a juror to understand, that's something that can be a cue for thinking about a way to engage the jury visually. If it's complicated, you definitely want to think about a visual. And then if there's lots of money tied to a particular item, and this seems trivial, but again, these are the types of things that should be tickling you in your mind to say, I need to get this message across via all means possible. So for a moment, just resist the urge to put this in front of jurors, and you will not believe what I see in trial. It was 3 weeks ago. I saw someone give an entire opening statement reading from slides that looked like this, almost verbatim. He read them all right, but it was as though he should have had this on a screen in front of him as a teleprompter, and that's it. It was terrible. But it's not like people don't do it. But this is not this is not an effective way to reinforce your points. In fact, I think it's counterproductive, and it's off-putting to see someone literally read from a PowerPoint in front of the jury. That's not what they're expecting. They're expecting something a little bit more polished. If you poll them afterwards, if you talk to them and get their feedback, they're interested in seeing a level of professionalism, seeing you represent your client, very well. And part of that is delivering a professional presentation of the evidence. And so don't fall victim to this, that you want to stuff a bunch of slides with bullet points, because this is not the same as having a high quality visual to go along with it. Subscribe to emotion, importance, complexity, and dollars, and let that guide your thinking behind preparation of visuals. So the next quick piece, well, I'm gonna say quick piece. The next component of engaging people visually in the courtroom and putting on the evidence in the best possible way involves the intersection of technology. So even if you have the best evidence, the best demonstratives, that you've got everything else. If people can't see it and absorb it properly in the courtroom, it's kind of all for naught. So the technology itself is important, but your personnel is also important. So this is my brother, who's co-founder of Elite Trial Consultants. He has been at it for a long time as well, and you want someone who's been there and done that in terms of experiencing a variety of different things in the courtroom and outside. So Ryan's background was in IT before getting into the courtroom to assist with the technology there. He's got great intuition, versatility, but he's ice cold, because any sort of computer problem that's ever been experienced, he's probably already dealt with it. And that's one of the things that you want to look for in the personnel that you have supporting your operation, right? If you look at what your return policy is like when it comes to trial, it's not very good, right? We get one shake at putting on the evidence, and there's a lot of people that will tell you stories about not being able to get a witness in, not being able to get a CAD file or something like that they wanted to use and couldn't. There's lots of horror stories out there, and at the end of the day, just working with people that are in trial a lot is your best bet in terms of putting on the case in the best possible way. And so I like to brag on my brother a little bit, because like I said, he's dealt with it all, and we have the plan B, right? So my presentation software dies. What do? Right? Do we throw up our hands and say, Your Honor, I'd like a short recess to sort it out? Well, that's what happens if you don't, but I would rather pull up the documents in another program, or do what's absolutely, the best that we can to make a small hiccup that most people won't even notice, versus interrupting the trial. So your personnel is important. The software that is used is also important. And until last year, we were using Trial Director 6. They have had Trial Director 360 out for a long time now, and I have finally decided just to not mess with it at all. Excuse me. It's a nightmare from the hot seats perspective. It doesn't open documents natively. It's very slow. There's all kinds of places for it to break. I used it side by side in a trial a couple of weeks ago, their latest version, now that they're discontinuing TD6, and the results were not good. And so I am only endorsing OnQ at this point. There's a new version of it out that I'm using, or it's a late stage beta, and I'm going to switch to that real quick, so we can see the things that we're trying to do in the courtroom. And the one thing that it couldn't do before, OnQ couldn't do before, was produce a very nice call out. And now we have the call out, and actually I would say there's two things, and then highlighting on the fly. So if you're reading, I like to follow along with what's being read so that people can see exactly what you are talking about as the attorney. So if you want to, if you say, hey, which standards is Adobe focused on in the courtroom, you might say, look, you can see Adobe demonstrates our commitment to security by implementing a range of important industry standards. This is how I like to display the evidence in trial. And again, capitalizing on that propensity for the eyes to draw focus to where we want them to. Our attention follows that. And I think that this is the best way to go through a document, is by having it go word by word while it's being read, and so on and so forth. So that's the reason for why I used to use both, and now in the latest version of OnQ, that will be accessible to everybody here the first quarter of this year. This is the right piece of software to take the trial. It's far more reliable and does everything I want it to do. And then the key differentiating factor has always been, if you want to play a deposition, it highlights the transcript as it goes, each line. And so that's something that I've really appreciated over the years, and from feedback from jurors, they find that, again, this is the best way to absorb the information. It's both to see the person testifying and then see the words as they're being read. Is a great way to see and internalize the testimony. So the next piece, is just the technology itself, or the equipment itself. So we bring in monitors for the judge, the witness, plaintiff, defense, the clerk, perhaps, if they need one. Sometimes the court reporter, and whoever else needs some. Sometimes if you're going with a large trial team, you may want 2 or 3 monitors on your side. Your client may want one. Every setup's a little bit different. But when it comes to determining whether something gets admitted or not, it's very nice to be able to pop the evidence up on the screen, not have it in view of the jury, have everybody be able to see it, talk about it. This creates a very efficient trial. You have less sidebar required. This is just what we're bringing into the courtrooms as a standard package. When it comes to visibility, this is less of an issue these days. In the heart of COVID, it was a huge issue, but it used to be in most boxes, jurors were about 10 feet from the screen, the furthest juror from a TV that might be in the courtroom. In the COVID environment, you may be 20 feet or more away from the screen that you're presenting evidence on. So what that looks like, this is a courtroom in Denver District, and this is not as big of an issue now, but the jurors surprisingly are being left up to their own devices in terms of social distancing. So the jurors that used to be all sitting next to one another in the box, I would say at least the last 3 trials I've been in, none of them have been sitting next to one another. They're utilizing the entire box to stagger and put at least a little distance between themselves. So you don't have this quite as extreme, but the televisions that are in most of these courtrooms are too small and are not providing the level of visibility that you may want, to put on your case. So we're bringing in a variety of different pieces of technology. In every trial this year, with one exception, I've had a remote witness to accommodate. And doing that well is easier said than done. Sometimes it requires extra equipment. Sometimes you need different cameras. Depending on what people want to do, it is not the easiest thing to have remote testimony both occur effectively and to make your witness comfortable, and so on and so forth. So we're recommending that you do a tech meeting with your remote participants ahead of time, get them comfortable with the platform that's being used, get them comfortable with the computer, the camera, the microphone that they're going to be using. That's something that you want to do before. The judges absolutely hate it when you can't get a remote witness. If you have AV issues, they can't be heard. It's just something that you don't want to deal with. So it's something that it needs to be addressed, and addressed well. Along the lines of the TV screens or the visibility, again, if it's a small screen, you can't read what's on it. That's why a lot of times we'll bring in both a TV and a projector screen, and legibility becomes much better. So sometimes small TVs that are in the courtrooms, most of the time, I believe, are just too small. People are squinting, and if they're spread out all over the box, they're not going to be seated well. So we bring in 75-inch TVs and relatively large projector screens, and this is really the best way to ensure that people don't experience fatigue, right? Even if it's just documents, you want them presented well by somebody who knows how to make them look as big as possible. That's not Dumbo huge. It doesn't take, if you've spent a lot of time in trial, you understand that there's a lot of documents are fuzzy. They're not the easiest to read, and minimizing jury fatigue is accomplished by having, the right displays in the courtroom. Last topic I'm going to talk about is execution. So when it comes to, all of these things so far, we know you got to collaborate early to develop your demonstratives. You got to pick the right types. You got to have the technology to use them. You got to have the right personnel supporting you. And then we want you to rehearse it. So a lot of that occurs by yourself. But if at all possible, take some extra time to do a dry run with your support personnel. Do it by yourself. But if you're going to be utilizing the technology to do it really effectively, our best teams are requesting to do a dry run of the opening, to get that sequence just right, to take a few extra minutes where we say, hey, this is where I want to slide up. I want a blank screen through here. I'm going to talk through this section of my outline. This, I want to cue that bullet point, that one right when I get to here. I want to see that. I don't want to see this. That's the great way to put on a really good show in trial. And it's not a show at that point. It just looks, like a professional production, and it's perceived very well. So that's the last component of the claiming the visual high ground. And if you follow that recipe, you'll not only claim it, you'll own it. People will recognize it. I did a case here two or 3 weeks ago, and we actually had an attorney from a firm that I've done business with in the past, a long time ago, but he was actually there through this trial, selected as a juror. And he said, the way you guys work together was impressive. Our firm needs to step up its game. And so I'll be doing the same presentation for them, probably, January of next year. But it's a great thing to see it unfold, and when it's done well, it's great. So really appreciate you guys listening through so far. Anybody who has any questions, I'm very happy to answer it. I know it's fairly dense, a lot of information there, and I guess I'm not sorry, but there's a lot of information, and I appreciate you taking some time to to absorb it. But if you have any questions, I'm happy to address them. If not, we can hopefully see you here at the next happy hour, and be able to talk a little bit more soon. I'm sorry, Steve.
Thanks. I had also heard about you from Colleen's partner, David Driscoll, who's a good friend of mine, and I can tell the others how impressed he was with the help, which Colleen already said, and I can tell you, I can reaffirm that. I'd like to get some information about your availability and the expense for a trial starting January 31st. Where do I do that?
I would send an email, or I would just call me. So the number that's there, I would say that's the best way. Just give me a quick call. I can tell you that week I don't have a trial scheduled. I think I have one the week before, but I believe that week's open. So in terms of availability, I think we're good there. In terms of expense, it is definitely a chunk when you're going to trial. There's lots of expenses. Just figure around $10,000 a week for if it's a full week trial or a multi-week trial. That's probably the right number. Certainly can be less, can be more, but that's about the right ballpark.
That's what I was looking for. Thanks.
Okay, thank you very much, Steve. All right. Colleen, do you have anything you wanted to say to the group before we sign off for the evening?
That's all. Stephen, thank you. Thank you so much for taking the time to speak with us today. Everybody here on the Zoom, thank you for joining us tonight. Feel free to pass the good word on to friends, colleagues. This program, as well as I believe, and Kyle, if I'm wrong, please just jump in screaming no. But I think a great deal of CLE material is currently available through the Boulder County Bar Association's website for home study. So if you are looking at the clock and going, oh geez, that December date is coming up, definitely head to the BCBA website to access additional CLE materials and let your colleagues know as well. So that's all I have. Doug, thanks for joining us. Stephen, thanks for joining us. And hopefully we will see everybody again soon.
That's good. Thank you.
Thank you.
Good evening, everyone.
Appreciate it.
You all
Thanks,
too.
everyone. Have a good night.